Tēnā koutou, tēnā koutou, tēnā koutou katoa, ko Christopher St. Johanser taku ingoa. I've been invited by the People's Inquiry to record this video, which I hope will inform you to some degree of the events that have taken place in the Brook Valley in Nelson and why they are of relevance to that inquiry. I moved into the Brook Valley after the death of my parents when they had their home there. And at that time it was a pleasant semi-rural area with a wide variety of recreational opportunities, including access to the head of the valley, which used to be the main water supply for the city, and a number of other walking tracks and things of that kind. Because I am a trained community worker, it seemed to me to be natural and obvious that it would be a good idea for the people of the area, quite tightly defined locale, to be able to communicate with each other, to befriend each other, and to share what concerns they might have about the way in which the Brook Valley was managed, if you like, by the Nelson City Council and other responsible authorities. This we did. We started going in 2013. We were incorporated a year or so later, and we found that we ran right up against the Nelson City Council in a number of different ways. The whole history would take far too long to expound. All details have been recorded, but perhaps it's sufficient for this to say that our concerns were that the Nelson City Council decided to privatise, by way of a long-term lease, the upper end of our valley, the head of the valley, some 70 hectares or so of land, and to enclose it within a 14-kilometre long perimeter fence by way of that lease to a private trust organisation, the Brook Waimarama Sanctuary Trust. This was opposed by ourselves for numerous reasons, including the total unsuitability of the terrain, which is comprised of what are called the Brook Street volcanics. Basically, it's volcanic sand tipped on edge, highly unsuitable, and this has been proven by the number and frequency of slips destroying that fence line in various places ever since. But that's kind of beside the point. The main thing was that they intended that the Sanctuary Trust be allowed to poison the valley with brodifacoum, and they proceeded to make arrangements with them through the process of the RMA to make this possible without anything in the way of public consultation. When we became aware of this, we became alarmed. We thought that we should indeed have the right to have something to say about the idea that so many tons of brodifacoum bait should be laid in 3 successive aerial drops at the head of our valley. However, we were excluded from public participation entirely, completely. Initially, this was done by way of what I can only refer to as a fraud, and that was when the Sanctuary Trust used the information obtained by an organisation called Wildlands Consultants to provide an assessment, an environmental assessment, to the Nelson City Council, of which the most significant feature was the wording that any environmental effect of the poisoning would be, quote, less than minor. That's a key phrase, and that key phrase allowed the Nelson City Council to say that no public consultation on the matter was required. In fact, that phrase generated by Wildlands Consultants, it needs to be known as it was not, and the Nelson City Council was remiss in the extreme or complicit in the fraud, in that the Wildlands Consultants as a company was owned by the same three people who owned the company that then went on to build the so-called predator-proof fence. We made numerous submissions, as they put it, to the Nelson City Council. We tried every avenue that was available to us. We considered the Environment Court as a possible way of moving forward. That seemed to be less satisfactory, in fact, than going to the High Court, which is what we did. So we took the matter to the High Court in Nelson, and as plaintiff, and the defendants in this were the Waimara Sanctuary Trust and the Minister for the Environment, who, as it happens, then was also the Member of Parliament for Nelson, Dr. Nick Smith, whose name will come up again shortly. The reception of the process was always antagonistic. We never received anything like proper consideration. An independent commissioner was appointed, supposedly, and I have his report here, and he was satisfied that the Nelson City Council, under section 34A of the RMA, he records that having read the application documents, the reporting officers section 42A report, that's one Alec Luverdis, the submissions and the evidence presented before, at and following the hearing, and having considered the various requirements of the RMA, he was satisfied that the applicant had undertaken a thorough assessment of the potential adverse effects that might arise from the storage and use of baits containing brodeficum by way of aerial and land-based application methods. And I stress again that we are talking about an extremely toxic substance. The excuse provided was that you can buy it on the shelves in the supermarket, which is still unfortunately the case. I don't propose to go into the toxicology of the matter, only that the assessment that the effect on the environment would be less than minor was a frank lie, and a method by which full public consultation was avoided. So that's why we decided to take legal action, because we wanted to do what we could to prevent this poisoning from taking place. I've been asked to provide whether there was any evident harm witnessed after the poisoning. Well, what we do know is that people were actually dusted with the toxic spray when there was a public protest at the gates of this new fence, including one councillor, Tim Skinner, and others of my friends and associates, some of whom have certainly reported that they have been poisoned by this toxin. There were 3 aerial drops, and people living close to the area were concerned. There was one gentleman who actually lived very close, right by the fence, and was most concerned because he took his water from the Brook stream. There had been no effort whatsoever to prevent the toxin from being absorbed into the streams. Off it went. The project itself of the predator-proof fence sanctuary was at that time strongly approved by the government, and was put through without public consultation. As far as we were concerned, it's a large area, and our recreational opportunities were, of course, completely removed. We couldn't get into the fence, into the area enclosed by this fence, which itself was an environmental devastation. The situation now is that it's been a commercial failure. That the fence continues to fall over with slips on these highly unstable slopes. That I believe it's the case that mice are now present throughout the sanctuary. The events of these last few years have left the local community disenchanted, not only with the disappearance of their recreational opportunity, but also with the manner in which this whole matter was dealt with initially by the Nelson City Council and subsequently by the minister, and then by the courts when it was taken, when we took it through the court process. A question I've been asked is, what were the main failings of the process we experienced? It can be put pretty simply, and that is that nobody wanted to hear what we had to say, and we weren't supposed to say it anyway. I would allocate responsibility now to the corporatisation of the local authority and to the clear intention of the Nelson MP, Nick Smith, to ensure that this proposal was pushed through regardless of anybody else's opinion. And that was made quite clear. We were unsuccessful at the High Court. That judge ruling against us on the grounds, if you can believe it, that a hazardous substance is not a substance. You might like to think about that for a moment. On that ground, we were ruled against. This was inadequate. We decided to appeal and took the matter to the Court of Appeal, which did hear our case, hear our appeal, and to its credit, the Court of Appeal recognised that this argument that a hazardous substance was not a substance was a bit rich, and dropped that as a ground for ruling against us. But they picked another ground to rule against us, and that was that in this case, the substance was in fact a structure. Yes. It gets quite disillusioning to hear apparently, supposedly learned people searching for words to discredit the case when it was quite clear that we had been denied any opportunity to speak to this proposal to poison our valley. In the course of this Court of Appeal hearing, the minister, Nick Smith, organised the Department of Conservation to address the fact that the rules regarding toxins had lapsed. In fact, there were no covering rules. They lapsed some 10 years before and nobody had noticed. So he not only decided to fix that gap, but he also made a recommendation to the Executive Council of the New Zealand government, that is, that an exemption should be granted to the regulations under the RMA, allowing initiatives such as this predator-proof fence sanctuary to be exempted from any RMA controls, which, as it turned out, was a source of major indignation to the independent commissioner, who'd gone to some trouble to try to sort this situation out. It was all taken completely out of his hands, and none of the conditions that he imposed on the Sanctuary Trust then had to be employed with. Excuse me, I think perhaps 3 still remained after this business. You'll appreciate that this is a source of considerable frustration to us all. We know, because we have the record, that the minister told his cabinet colleagues that it wasn't a side effect of the exemption that the public should be excluded. It was, in fact, the intention that the public should be excluded from from consultation in this and other matters. And this is something that he coined the term streamlining for. Unfortunately, this streamlining has fixed itself in government policy after the election and the appointment of a new Minister for the Environment, David Parker. He happily continued to apply this streamlining process by which communities and individuals were excluded from any form of participation in the decision making about their own areas and whether or not they were going to be poisoned at City Council's behest. Well, we didn't stop there. We decided that this was the idea that the substance was in fact a structure, and therefore, I still can't understand I'm not a lawyer, but I still can't understand why, having decided that the ground that the High Court proposed, that the hazardous substance was not a substance, that having been applied to dismiss our case, why the Court of Appeal simply didn't say, well, the ground for dismissing your case was inadequate and therefore your case is not dismissed. It is upheld. But no, they searched for and found another ground, or so they say. Well, we weren't happy with that either, so we then approached the leave panel of the Supreme Court of New Zealand for them to review the decision of the appeal court. We were heard by a panel of 3, and these judges decided that the matter was of insufficient public interest for the matter to be put before the Supreme Court for its ruling. I regret to say that the appearance is very much that the public have been completely excluded on totally inadequate grounds from a decision as to the poisoning of the environment in which they live. And this seems to me to be grossly unjust. And I'm very hesitant to be critical of the judiciary, but critical I am. I think it suggests strongly that these judges, who are in fact appointed by the Attorney General, and that Attorney General being David Parker, who is also the Minister for the Environment, or was in the last government, and still is, in fact, and has consolidated his position of power. And what we have basically is a politician being able to, through his office as Attorney General, through his subsidiary, his junior, if you like, the Solicitor General, through Crown Law, to be able to influence the decisions of judges in particular cases. That's my suspicion. And I think that's a highly unsatisfactory situation. I am concerned even about mentioning it because there are dangers involved in making such criticisms. However, I've got a bit beyond being concerned about such dangers, because I think these matters are of very great importance. The final question I was asked was, how do I think this outcome impacts communities wishing to take legal action against non-compliant conflicted government agencies? Well, I'll be clear. I regarded this exercise from the beginning as an experiment, something of a scientific experiment to establish whether or not justice could be obtained through the judicial system on environmental matters. The case has always seemed crystal clear to me and to those of us who struggled and survived through this awful process that has occupied us so long. However, be that as it may, and you can tell that I'm still emotionally affected by these events, I think to answer that question profoundly is the answer, that we've demonstrated fairly categorically that there is no justice to be obtained for environmental matters in this country, that the corporatisation of local government, the neoliberal ideology adopted by successive governments have disregarded and put down public input in every possible way, so far as I can tell. So that I think people who are currently concerned about, as we are also, the dropping of 10-AG poison around the country, or the mining of the seabed, any number of such local issues, local or regional issues, the grassroots organisations, flax roots organisations that attempt to obtain redress are hampered from the start by the fact, essentially, that the Parliament and the government are absolutely unwilling to listen, because they are all co-opted, as appear to be the judiciary as well. That's what neoliberalism has done to us. That's my view. Thank you, People's Inquiry, for this opportunity. This has not been an easy exercise to undertake. I do hope that it is of some value to obtaining that redress. There are mechanisms. I won't go at length of them now, but certainly there's a possibility that the Law Commission may develop a system by which class actions can be taken, as they cannot be currently in New Zealand, and that with class action suits and litigation funding, it might be possible for a coalition of concerned citizens to be able to take these matters forward and to punish those people who have so abused our democratic processes. Thank you very much.